Oh, good morning, Facebook, and people following along. We are effectively going to take on a bank. Now, this work that's been done, the work that's been laid out thus far, was not done by me, but the parties that started it walked away, and I've been reading through it, and I'm absolutely enamored by the way it was structured. I love it. Absolutely love it. So I want to read you this real quick, and then I'm going to get into the meats and potatoes of the banking industry, okay? The guy that constructed this is brilliant, extremely learned, and a way of articulating it that's second to none. I'm very impressed. The certifying notary is an independent contractor and not a party to this claim. In fact, the certifying notary is a federal witness pursuant to 18 U.S.C. subsection 1512, tampering with a witness, victim, or an informant. The certifying notary also performs the function of a quasi-postal inspector under the Homeland Security Act by being compelled to report any violations of the U.S. postal regulations as an officer of the executive department. Intimidating a notary public under the color of law is a violation of Title 18 U.S.C. 242, titled Deprivation of Rights under Color of Law, which primarily governs police misconduct investigations. This statute makes it a crime for any person acting under the color of law to willfully deprive any individual residing in the United States and or the United States of America those rights protected by the Constitution and the laws of the United States. Pretty powerful. Now we're going to get into the meats and potatoes. I wanted to read that because it's very, very well constructed. I'm going to redact the names out of this, but I want to show you the clarity, the precision for the way this was written. And to do so, I'm going to redact the names for privacy's sake. From the desk of the executive office. Okay, listen to that. From the desk of the executive office. Okay, David Clarence points out the executive office, and David Clarence wasn't wrong about that. Okay, and for this, we'll just use David Clarence's name to continue on. From the desk of the executive office, David Clarence, care of David Clarence, all capital letters, borrower, and I put in there / debtor. We're performing a surgery here, and we don't want to go in with a machete to try and repair a clogged artery. We want to go in there with precision tools, a scalpel. Okay, so the words that are going to be used in this document are going to be extremely precise. It goes on with an address. Domestic Mail Manual, section 122.32, without a congressional district. Okay? What are we doing here, ladies and gentlemen? We're establishing political status without internal revenue district. Okay? To a bank, care of. Okay? We're addressing the man. It's not the bank that's harming this individual. There's a man behind the curtain, behind the veil, hiding behind a corporation, otherwise known as a bank. And we're addressing him personally, okay? Because he's liable for the damages and injury and harm that David Clarence may sustain in the event that this private administrative process, which they've already faulted on, by the way, okay? So it has the contract number, terms and conditions, intent and purpose to exhaust administrative remedies, sworn communication, show of cause, proof of claim, demand first notice, and demand. Now remember, ladies and gentlemen, there are a number of ways to remain in honor, okay? When somebody presents you something and you ignore it, you acquiesce and you default, okay? So you can either accept the terms and conditions and pay the debt due and owing. 2, to remain in honor, do a conditional acceptance by way of writ expressing to them that you're going to do a conditional acceptance provided they can prove their claim, okay? And that's what was done in this process. I, David Clarence, conducting the status or styled condition of David Clarence, the all capital name borrower, okay, because we know the all capital name is the debtor, and state, I have received your notice of right. And then it goes on to list the to cure loan default dated January 11, 2019 regarding account numbers, and there's 4 account numbers here. And I will accept your offer outlined in the letter under the following terms and conditions. What is he doing, ladies and gentlemen? Right there, he's doing a conditional acceptance. He's remaining in commercial honor, okay, by doing a conditional acceptance. The bank, aka this Terry, has made a claim against David Clarence here, and again, I'm using David Clarence's name because I'm redacting the names that are truly in the document. So Terry has made a claim. Terry has made a claim on behalf of the bank. Okay, he's acting as agent in agency as the principal for the bank, or the bank is the principal and he's acting as agent in agency. So we're moving forward here. And I will accept your offer outlined in the letter under the following terms and conditions: that you provide the following proof of claim. Your failure to provide proof of claim and to accept payment for credit on account shall constitute a breach of the agreement and subject to fines, penalties, fees, taxes, and other assessments. Ladies and gentlemen, this is powerful stuff. Proof of claim. The legal status of these non-constitutional legislative entities operating, functioning as source of authority for these so-called revised code statutes, and specifically the United States Code and or specifically the Act of March 9th, 1933, Proclamation 2038, 2039, 2040, and Titles 4, 7, 11, 12, 15, 16, 18, 28, 31, and 42 USC, CFR, the Federal Registry thereof is not that of a corporation, quasi-corporation, which is also created by statute. See 73, Corpus Juris Secundum, Private Administrative Law and Procedures, subsection 10, page 372, citing Parker versus Unemployment Compensation Commission, 214 Southwest 2D 529 358 MO 365, which states, the power granted to the administrative body may be such as to establish it as a legal entity, and although not expressly declared to be a corporation, it may be considered a public quasi-corporation. Texas and Pacific Railway versus Interstate Commerce Commission, 162 US 197, 1895, which states, the Interstate Commerce Commission is a body corporate which with legal capacity to be a party plaintiff or defendant in the federal courts. 2. Am Jurisprudence, 2nd edition. Administrative Law, subsection 32, page 56, which states, some administrative agencies are corporate bodies with legal capacity to sue and be sued. Show of cause, proof of claim demand. Proof of claim that the Legislative Reference Bureau, created by the Act of April 27, 1909, Public Law 208, and recognized by Act of May 7, 1923, Public Law 158, as a legislative agency with the primary function to draft and pass upon legislative bills and resolutions for introduction in the General Assembly, and to prepare for adoption by the General Assembly codes by topics of the existing general statutes for which it was handed over statutory authority in 1974 to publish an official publication of the United States Code, is not operating, functioning as an non-constitutional legislative entity, and is not operating or functioning as a foreign corporate entity representing the source of authority for the existence of statutes, laws known as the United States Code, in the capacity of an administrative law agency administering the corporate affairs and public of which created it by statute. Proof of claim number 3. These alleged statutes, laws of this non-constitutional legislative entity, i.e. Legislative Reference Bureau, operating, functioning as a foreign corporate administrative law agency, are not by nature akin private by laws of a corporation for the administration of of its internal government and public, and are binding and of force or effect over upon the private, non-enfranchised and non-assumpted thereto, and therewith, living, breathing, flesh and blood man, i.e. a natural person, man. Natural person, it's a very important topic there, okay? First-class citizens, second-class citizens. I mean, ladies and gentlemen, we really got to become learned on this, and we've got to pay attention to the spells they cast upon us with spelling, okay? As such, are not ultimately governed by, through, and within the realm of commercial laws, and adopted and codified within the United States Code thereby, and therein representing commercial law for operating functions in commerce. Proof of claim number 4. Whereas the Constitution for the United States of America at Article 1, Section 8 and 10 clearly prohibit Congress from printing and issuing Federal Reserve notes, as it is a constitutional entity, or purportedly so, and its actions are limited thereby and therein. A corporation or a trust is not, ergo, the Federal Reserve System created by Congress, Act of 1913, and as a non-constitutional congressional entity without the Constitution, and therefore not bound nor encumbered by said document instrument, may proceed to print and issue money, currency, okay? I don't like how he used the word money there, because we all know that money can be nothing other than gold and silver coin. It's written in the Bible, gold and silver are good. It was obviously put there by the heavenly creator for our use at a limited source. It also states that interest shall not be had in the Bible. Why shall interest not be had? For this very reason that we have today, ladies and gentlemen, where a wealthy group of families can decide how much interest you owe them based upon the products that they produce. And they don't produce anything, ladies and gentlemen. The FRN note has no intrinsic value. It is not gold or silver. It is not something that is made of metal. It's paper and ink. So I'll digress and continue on. The Federal Reserve System created by Congress Act in 1913 and a non-constitutional congressional entity without the Constitution, and therefore not bound nor encumbered by said document instrument, may proceed to print and issue money, currency, which would be an unconstitutional form of money for Congress. Again, I don't like the term money there, but it's there. Restrained as it is by the instrument document of its creation, this non-constitutional legislative entities, ergo the Legislative Reference Bureau, and the alleged statutes, laws they generate, is not a non-constitutional issue having no nexus with the Constitution, and the binding force or effect of said statutes, laws, is not established, created solely from or by contract between the parties, which once silent judicial notice of said contract is taken by the holder in due course, ladies and gentlemen, the holder in due course, any affidavit in support thereof, and specifically within the above referenced alleged loan, debt, security, instrument, unless said presumption of a contract is rebutted. Powerful. Please take note. Please note that although it is the United States Treasury Department who prints the so-called Federal Reserve notes, these notes have no value and are not backed by anything. Federal Reserve notes are not redeemable and receive no backing by anything. This has been the case since 1913. The notes have no value for themselves. That's right. Look at Venezuela, ladies and gentlemen. All that paper fiat's lining the streets now. I've literally seen photographs where it's just laying out there. People are weaving hand baskets out of it and purses. It has no value until somebody takes that paper, puts a little energy into it, and makes something constructive out of it. Then all of a sudden it has value. People are using scrupulous amounts of this paper in Venezuela to make nifty little purses. And they're kind of neat, to be quite frank. I want one just to say that I have something made out of something that once had value until people lost belief. And that's why I tell you, belief is the most powerful thing in the world. I will never try and change your belief. I can't do it. I can't do it, and I won't. But what I can do is cause you to question some things, cause you to look within yourself to find the truth, okay? The above referenced quote is taken from the official website of the United States Financial Excerpt. The United States Department of the Treasury, whose job it is to print the money to be utilized by the public. And note how they say that since the government declared bankruptcy in 1933, their notes have had no value. The Federal Reserve issues bookkeeping entry credit. The public side of the ledger, the private side of the ledger. Negative accounting, okay? Zeroing out the books. They always show zero, ladies and gentlemen. That's the issue, okay? The Treasury, whose job it is to print to be utilized by the public, and note how they say that since the government, the Federal Reserve issues bookkeeping entry credit. There is no constitutional amendment permitting the Federal Reserve and or the Treasury to create worthless items and declare them to be currency. The Constitution has held that the monies created by Congress must have a value. And this is not a market value, but a national currency value. Federal Reserve bookkeeping entry credit is not regulated by Congress, making this process by the Federal Reserve, the issuance of bookkeeping entry credit, unconstitutional. That is, unless and until you can provide facts and conclusions of law and not opinions to the contrary. Okay. Hey, HTTP, www, Treasury Gov, Resource, Center of Facts, currency page, legal tender, ASPX. Number 5, proof of claim that the original lender did not land bookkeeping entry credit in the form of a loan and failed to provide such notification and clear, unambiguous, conspicuous language terminology that any reasonable man or woman would understand, intentionally created fraud in the factum, and withheld from plaintiff vital information concerning said debt and all of the matrix involved in making the loan. This Dutch, I believe that's Dutch Bank, via Peabody, 866 New York, NYS 2D 91, 2008, Equa First. When making the loan, violated Regulation Z of the Federal Truth in Lending Act 15 USC subsection 1601 and the Fair Debt Collection Practice Act 15 USC subsection 1692. Now I want to talk to you about the Fair Debt Collection Act. The first word in the Fair Debt Collection Act is what? Fair. F-A-I-R. What does that tell us, ladies and gentlemen? That's your sign of equity. Fair equates to equity. What should be done shall be done. Now remember, equity doesn't aid a volunteer, and equity doesn't aid somebody that stands silent on their rights, okay? So there's very important movement in equity, and that's where we're going with this. We're going to create the trust. We're going to go ahead and put a lien on this man's land for his maintenance, his upkeep, his improvements to the property, his man's security. We're going to make sure that if these lying, looting, pandering thieves come in to take a ranch that has been in this man's family for 120 years, that they're at least going to compensate him for it, okay? We're going to make them think very, very hard about their next move. Now, it's not the bank. It's not the bank coming after him. It's a Terry. It's a man by the name of Terry who is going to be the CEO or the CFO of a specific bank, okay? So we're attaching the liability in personam, personally, to Terry for bringing an action for which relief cannot be granted and for which he can't prove he has any collected interest in. We know the bank didn't lend anything to David Clarence. And we know that Terry didn't lend anything to David Clarence. And on those two principles alone, we have them. Okay? But that doesn't mean that these lying, looting thieves aren't going to circumvent true justice and steal it anyway. Okay? Because as we know, by looking at Black's Law Dictionary, judge is a banker, and when you look up banker, banker is a judge. So where is the rightful remedy? And how is this alleged ministerial administrator sitting on the bench non-biased when he's got a collected interest in taking one's property and turning it from one to another? Okay? The Constitution is okay. Proof of claim. The original lender did not land bookkeeping entry credit in the form of a loan and failed to provide such notification in clear and unambiguous. I think I've read through that. Matrix. Yep. Okay. Fair Debt Collection Act. Anyway, fair indicates equity. The first word of it. So go read the Fair Debt Collection Practice Act. It's not very long, guys, and you should be able to comprehend it. Next, proof of claim number 6, that the banking holiday proclaimed by President Roosevelt under Proclamation 2039 prohibiting any banking during the course of such emergency to include but not limited to deposits, credits, receipts, withdrawals within and between banking institutions has been suspended, declared over, abolished, replaced, ? Proof of claim that the government loan represented by this account is not backed by the full faith and credit of the United States government ? Proof of claim that the government loan represented by this account is not secured by mortgage insurance and the holder in due course is the beneficiary of that. Mortgage insurance. That the mortgage insurance is in place should the borrower default. Okay? Now the borrower is a corporation, ladies and gentlemen. The debtor. Okay? The debtor. David Clarence is a creditor. The all caps is the debtor. Okay? Follow me on this. Proof of claim that the loan associated with the debt is classified as a personal loan and not a home loan. And that if it were to be classified as a home loan, the original lender would be responsible for capital gains tax. ? That the home is purchased not from a bank, but a private home owner. ? Proof of claim that the property securing the loan, an unsecured loan, has been fully paid as a result of the Treasury program and or other government programs respecting or associated with such loans, programs like the Single Family Home Loan Guarantee Program, etc. ? Number 11, proof of claim that issuing the loan in the form of a bookkeeping entry credit was deceptive, intentional, and deliberate attempt to conceal pertinent information regarding the origination of the loan and the matrix associated thereto. Okay, keep following. Here we go. Proof of claim number 12. The tax credit and or charge of whereby the government has issued credits respecting the associated loan debt has not been applied to the borrower's side of the ledger, indicating the adjustment in the balance. Number 13, proof of claim. The Uniform Non-Judicial Foreclosure Act, the Uniform Home Foreclosure Procedure Act, the Administrative Procedure Act do not recognize arbitration as an alternative dispute resolution remedy. ? Proof of claim that the associated loan has not been satisfied as outlined in the Uniform Satisfaction of Mortgage Act. ? Proof of claim that the borrower is entitled to a full and complete accounting as you and or your associates organization are the keepers of the record, the custodians of the record, and or to supply a full complete accounting of the record upon demand. Please note that demand is hereby made for a complete comprehensive accounting of this account. And the same deadline for furnishing a response to this presentment is the exact same deadline for furnishing the accounting as is demanded. Proof of claim number 16, that your organization nor the original lender ever intended on limiting lawful money as required in law, regulated by Congress, and prescribed by the Constitution of the United States of America. ? Proof of claim that number 17, that there is no lawful statutes and or constitution delegation of authority authorizing your institution in creating bookkeeping entry credit as a form of acceptable currency within the United States. Proof of claim that all property in the United States is owned by the state by virtue of government. ? That's number 18. Proof of claim number 19, that the following statement and or record of Congress remains extant. Mr. Speaker, we are here now in Chapter 11. Members of Congress are official trustees presiding over the greatest reorganization of any bankrupt entity in the world's history. The U.S. government, we are setting forth, hopefully, a blueprint for our future. There are some who say it is a coroner's report that will lead to our demise. Representative James Traficant Jr., Ohio, addressing the House Congressional Record, March 17th, 1993, Volume 33, page H1303. Number 20, proof of claim. That as a banking institution, the borrower may utilize bookkeeping entries as a form of acceptable currency as it was the initiating currency of issuance. Now, therefore, I, Franklin D. Roosevelt, President of the United States of America, in view of such national emergency and by virtue of the authority vested in me by this said act, do hereby proclaim, order, direct, and declare that there shall be maintained and observed by all banking institutions and all branches thereof located in the United States of America, including the territories and insular possessions, a bank holiday, and that during the said period all banking transactions shall be suspended during such holiday. No such banking institution or branch shall permit the withdrawal or transfer in any manner or by any device whatsoever of any currency, nor shall any such banking institution or branch pay out deposits, make loans or discounts, transfer credits, or transaction any other banking business whatsoever. During such holiday, the Secretary of the Treasury, with the approval of the President and under such regulations as he may prescribe, is authorized and empowered, A, to permit any and all of such banking institutions to perform any or all of the usual banking functions, B, to direct, require, and permit the issuance of clearinghouse certificates or other evidence of claims against assets of banking institutions, and C, to authorize and direct the creation in such banking institutions of specific trust accounts for the receipt of new deposits, which shall be subject to withdrawal on demand without any restrictions or limitations, and shall be kept separately in cash or on deposit in Federal Reserve banks or invested in obligations of the United States. Obligations of the United States. Ladies and gentlemen, all debts are obligations of the United States and shall be offset and discharged through the United States Treasury or the state of whatever you're in, Treasury, okay? As used in this order, the term banking institution shall include all Federal Reserve banks, nation banks, associations, banks, trusts, companies, savings banks, buildings and loans associations, credit unions, or other corporations, partnerships, discounting, business paper, or transacting any other form of banking business. Proclamation 2039, declaring bank holiday March 9, 1933, public papers and address of Franklin D. Roosevelt, declared law by General Assembly, U.S. Congress, March 9, 1933, and the act of associated by the same name. Proof of claim 21, that the loan and the associated debt and the obligation of the United States as defined in statute, September 14, 1976, the Senate Special Committee had found that President Roosevelt's 1933 proclamation of a national emergency was still extant. See Senate Special Committee on National Emergencies and Delegated Emergency Power Final Report, National Emergencies and Delegated Emergencies Powers, S. Rep. number 94-922, 94th Congress, 2D, Session 1976, Public Law 94-412, September 14th, 1976, 90 Stat 1255, 50 USC 1601, Estet Sec. 22, proof of claim that the ownership of all property is not in the state. That's going to be a tough one for the bank to prove. And that individual's so-called ownership is only by virtue of the government, i.e., i.e., law amounting to the mere user, and that use must be in accordance with law and subordinate to the necessities of the state. Senate document number 43, 73rd Congress, first session. 23, proof of claim. Under the new law, the money is issued to the bank in return for government obligations. The money will be worth 100 cents on the dollar because it is backed by the credit of a nation. Who's the credit, ladies and gentlemen? You, me, your offspring. That's the credit, okay? That's the credit. There's the value. Your energy that God has bestowed upon you. Your energy is the value. See, before it became DHHS and all this stuff, it was health and human, what, ladies and gentlemen? Resources. What's a resource? And why would they proclaim that they manage health and human resources? Ladies and gentlemen, let that sink in. Open your mind, broaden your horizon, okay? Under the new law, the money is issued to the banks in return for government obligations. The money will be worth 100 cents on the dollar because it is backed by the credit of the nation. That it represents a mortgage on all the homes and all the people of the nation. Congressional Record, March 9th, 1933, on House Resolution 1491, page 83. I'm giving you the facts, ladies and gentlemen. And again, I didn't construct this, but man, is it beautiful. 24, proof of claim that it has been resolved by the Senate and the House of Representatives of the United States of America and the Congress assembled that A, every provision contained in or made with respect to any obligation which purports to give the obligee the right to require payment in gold or a particular kind of coin or currency or in an amount in money of the United States measured thereby is declared to be against public policy, and no such provision shall be contained in or made with respect to an obligation hereafter incurred. Every obligation herefore or hereafter incurred, whether or not any such provision is contained therein or made with respect thereto, shall be discharged upon payment. Dollar for dollar. Ladies and gentlemen, when they bankrupted, when they had their coup d'etat in 1933 and it was a hostile takeover of the United States of America and placed into the hands of the banking cabal, all obligations are of the United States, period. Every car sitting on a car dealership lot is already bought and paid for and waiting for somebody to come take care of it and utilize it, okay? Every home has a use and has been bought and paid for. Think of those mortgages that have been created. Think of those promissory notes that have been created. How many times does a house sell? And how many times do they get a letter of satisfaction on the mortgage? But here's the question. Those promissory notes from 1930, are they still 1935, 36, 40s? Are they still floating around on the house that you live in today? How many times has that house been bought and paid for? And nothing has been offset and discharged from the private side of the ledger? Where are those promissory notes? How are they still in circulation? Who's trading them? Where are these securities, ladies and gentlemen? Okay? Think about this. Open your mind. Particular kind of coin or currency, or an amount in money of the United States measured thereby, is declared to be against public policy, and no such provision shall be contained in or made with respect to an obligation hereinafter incurred. Every obligation herefore or hereafter incurred, whether or not any such provision is contained therein is made with respect thereto, shall be discharged upon payment, dollar for dollar, in any such coin or currency, which at the time of payment is legal tender for public or private debts. The Gold Abrogation Act of June 5th, 1933. Now, it brings up a very valid point here. Okay, if things are supposed to be discharged dollar for dollar, because they've effectively taken our money, gold and silver, right? And he who provides an ends provides a means, right? If I need you to do something, and although you physically can do it, but you lack the tools, but I still expect it done, don't I have an obligation to make sure that you have the tools you need to complete the task? Absolutely I do. Or I can't compel you to perform. I can't expect you to perform a task that needs certain provisions, certain tools to accomplish the task at hand. Right? So he who provides an ends also provides the means. Number 25, proof of claim that since March 9th, 1933, the United States has been in the state of declared national emergency. This proclamation gives force to 470 provisions of the federal law. These hundreds of statutes delegate the president extraditionary powers exercised by Congress, which affects the lives of American citizens in a host of all-encompassing manners. This vast range of powers taken together confer enough authority to rule this country without reference to normal constitutional process. Senate Report 93-549, July 24th, 1973. 26, proof of claim that the following is the current understanding. This gets good. Would like to ask the chairman of the committee if this is a plan to change the holding of the security back of the Federal Reserve notes to the Treasury of the United States rather than the Federal Reserve agent. Mr. Stigall, this provision is for the issuance of the Federal Reserve banknotes and not for the Federal Reserve notes. And the security back of it is the obligation notes, drafts, bills of exchange, bank acceptance outlined in sections to which the gentleman has referred. McFadden. The new circulation is to be the Federal Reserve banknotes and not the Federal Reserve notes. Is that true? Stigall. Insofar as the provisions of this section are concerned, yes. Mr. Brighton. From my observation of this bill as it was read to the House, it would appear that the amount of banknotes that might be issued by the Federal Reserve System is not limited. That will depend entirely upon the amount of collateral that is presented from time to time from exchange for banknotes. Is that correct? McFadden. Yes, I think that is correct. The congressional record during the debate over the Emergency Banking Act of 1933. Number 27, proof of claim that the amendment of subsection 5B provided that the act can only be invoked during the time of war. The elimination of the exclusion made clear that any and all emergency powers that might have previously been available pursuant to the National Emergency Declaration under subsection 5B, Congress did not formally terminate the one declared by President Roosevelt, apparently believing that only the president could do so. Excuse me for just a second, I gotta grab some more coffee. This cup just isn't big enough. And we're back. And so, 50 U.S.C. App 5B, 12 U.S.C. 95A. In amending TWEA, Congress did provide for the continuation of the emergency and of economic sanctions that were the result of the presidential declaration of national emergency that were in effect on July 1st, 1977. Subject to the automatic termination unless they were renewed annually. The provision allowed the continuation of the national bankruptcy and the national banking holiday, as well as the sanctions on regimes like Cuba, North Korea, China, and North Vietnam to continue without the president having to declare a new national emergency under the IEEPA C50 USCA App 5 Note. 28, proof of claim. That as the first adopted in 1976, the National Emergencies Act excluded from its purview Section 5B of the Trading with the Enemy Act, as noted above. The law under which President Roosevelt issued the Declaration of National Emergency with respect to the national bankruptcy was never canceled. With the Cold War, sections under that act had also been used by the executive branch as a legal basis for imposing economic sanctions on the communist nations of North Korea, Cuba, China, and North Vietnam. And the National Emergency Act had been terminated. Had it been terminated, there would have been no other legal basis for continuing the sanctions against those countries, except to enact a set of new specific laws Congress chose not to consider. As a consequence, the State Department asked the Section 5B be excluded from the National Emergency Act until other legislation providing a basis for the continuation of economic sanctions against those countries could be enacted. Is this not the case? Question mark. Number 29, proof of claim. That whatever in the judgment of the Secretary of the Treasury, such action is necessary to protect the currency system of the United States. The Secretary of the Treasury is in discretion, may regulate any or all individuals. Whoever shall not comply with the provisions of this act shall be fined not more than $10,000, or if a natural person may, in addition to such fine, may be imprisoned for a year, not exceeding 10 years. Stat 448, Section 1, Title 1, subsection in March 9th, 1933, that it is under discretion and the direct supervision of the United States Treasury that the banking institutions are utilizing bookkeeping entry credit. And because of the law defines a banking institution as one who engages in the business of banking, i.e. banking business, during the current national banking emergency defined in the law as bankruptcy, such bookkeeping entry credit utilization is construed as currency of the United States and may be utilized for the payment and or repayment of a loan instituted and or issued in the same species. Is this not true? So, question mark. Caveat. Number 30. Please understand that while the undersigned wants, wishes, and desires to resolve this matter as promptly as possible, the undersigned can only do so upon respondent's official response to the conditional acceptance for the value and counter offer claim for proof of claim by respondent, providing the undersigned with the request and necessary proof of claim raised here and above. Please consider this account in a formal dispute and protected under, without limitations, 5 U.S.C. subsection 571, 584 through 584, 15 U.S.C. subsection 1692, page 1692, CFR 226.13 D12. Accounts in formal dispute are as follows, and it lists the name of the account or the number of the accounts. Therefore, as the undersigned is not a signatory nor a party to your social compact contract known as the Constitution Charter of the United States, nor notice nor cognizant of any agreement, contract between the United States and the undersigned, and specifically any obligation through full disclosure and containing any fair, valuable consideration therein, which would act, operate to create and establish a relationship, nuxus, and thereby and therein binding the undersigned to the specific source of authority for the certain and existence of the alleged statutes, laws as contained and allegedly promulgated within the code known as the United States Code, which with the privity of contract of a or contract itself would thereby and therein create and establish legal force and effect of said statutes, laws over and upon the undersigned, and would also act, operate to subject the undersigned to the statutory jurisdiction of the United States, its laws, venue, jurisdiction, and the like of its commercial courts, administrative tribunals, units, and thereby and therein binding the undersigned to said courts, administrative tribunals, units, discretion, orders, judgment, and the like. And specifically, as within the above referenced alleged commercial civil cause and which would operate to establish and confer upon said court administrative tribunals until the necessary requirements essential of subject matter jurisdiction, without which it is powerless to move in any action other than to dismiss. The undersigned once more respectfully request respondents provide said necessary proof of claim so as to resolve the undersigned's confusion and concerns within these matters. Otherwise, the undersigned must ask, what is the undersigned's remedy? Number 32. Therefore, as respondent having superior knowledge of the law, access to the requested and necessary proof of claim, and otherwise being in a catbird's seat to provide the requested and necessary proof of claim raised herein above, respondent is capable, and most qualified to inform the undersigned on those matters relating to and bearing upon the above referenced alleged civil commercial cause, and thereby and therein clearing up all confusion and concerns in said matters for the undersigned. As to the nature and cause of said process, proceedings, and the likes of, as well as the lawfulness and validity of such to include inter alia all decisions, orders, and the like within the arising form, all such within the commercial civil cause. Number 33, the undersigned herein and hereby provides the respondent 10 calendar days to commence the day after receipt of this conditional acceptance for value and counteroffer claim for proof of claim, in which together provide the undersigned with the requested and necessary proof of claim raised herein above, with the instructions to transmit said proof of claim to the undersigned and to below named notary third party for the sole purpose of certifying response or want thereof of respondents. Further, the undersigned herein and hereby extends to the respondent the offer for an additional 10 calendar days, or up to 20 days, in which to provide requested and necessary proof of claim raised herein above. If respondent desires the additional 10 calendar days, respondent must cause to be transmitted to the undersigned and the below named notary third party signed written request. Okay? We're asking for a response. We're asking for performance. If they fail to perform, they acquiesce, don't they? And acquiescence is very powerful, ladies and gentlemen. Upon receipt thereof, the extension is automatic. However, the undersigned strongly recommends the respondent make request for an additional 10 calendar days well before the initial 10-day calendar days have elapsed to allow for mailing time. Notice, should respondent make a request for additional 10 days, said request will be deemed good faith on the part of the respondent to perform to his offer and provide the request and necessary proof of claim. Should respondent, upon making a request for additional 10 calendar days, then fail or otherwise refuse to provide the requested and necessary proof of claim, said acts on the part of the respondent shall be deemed and evidenced as an attempt, constructive fraud, deception, bad faith, and the like upon respondents part, and further attempt to cause and or inflict injury upon the undersigned. Further, the undersigned herein strongly recommends to the respondent that any proof of claim and request for the additional 10 days calendar days be transmitted certified mail, return receipt requested, and the contents therein under proof of mailing for the good of all concerned. Okay? Right now he's laying out the structure of this private administrative claim. And they're like I said, we're not going at it with a machete, ladies and gentlemen. We're going in there with a scalpel. We are making incisions, precise incisions. Should the respondent fail or otherwise refuse to provide the requested and necessary proof of claim raised herein above within the expressed period of time established and set forth herein, respondent will have failed to state a claim upon which relief can be granted. Further, respondent will have agreed and consented through tacit acquiescence to all the facts in relation to the above referenced alleged commercial civil cause, as raised herein above, as proof of claim, and all facts necessarily and of consequence arising therefrom, are true as they operate in favor of the undersigned, and that said facts shall stand as prima facie evidence and ultimate unrefutable between the parties to the conditional acceptance for value counteroffer claim for proof of claim, the corporate government judicial constructs, respondents representative serves, and all officers, agents, employees, assignees, and the like in the service to the respondent as being undisputed. Further failure and or refusal by respondents to provide the requested and necessary proof of claim raised herein above shall operate as ratification by respondent that all facts as set, established, and agreed upon between the parties to the conditional acceptance for value and counteroffer claim for proof of claim are true, correct, complete, and not misleading. Okay, arbitration and administrative remedy cognizable at law. Number 35. Additionally, it is exigent, E-X-I-G-E-N-T, exigent, and of consequence for the undersigned to inform respondent in accordance with the pursuant to the principle and doctrines of clean hands. Ladies and gentlemen, what we talk about, clean hands? Clean hands, we're talking about equity, baby. And I love equity. Joseph's story. You need to get into it. You need to start reading Joseph's story. I can't express to you the brilliance of that man who studied under John Marshall, became a federal Supreme Court justice, wrote 14 or 15 books specifically on equity, never passed the bar, never was an esquire. Okay, ladies and gentlemen? Powerful. Okay? Requested necessary proof of claim raised here and above, thereby and therein expressing consent and agreement to said facts, and as a result of the self-executing agreement, the following is cognizant upon their failure to respond in good faith with specificity with facts and conclusions of law to each and every averment, okay, condition and or claim raised, as they operate in favor of the undersigned. Through tacit acquiescence, respondent not only expressly affirms the truth and validity of said facts set, established, and agreed upon between the parties to this conditional acceptance for the value and counteroffer claim for proof of claim, but respondents having agreed and consented to respondents having a duty and obligation to provide the requested and necessary proof of claim raised herein above will create the established for respondent an estoppel in this matter. An estoppel. Okay? And that's why, in this process, we want to file a lien on the property right away. Okay, we already know that they're in the wrong. We already know that they can't prove any of this stuff. We already know that we have them. And by right, they've already defaulted. But there was some fundamental errors that were made in this process that weren't followed through properly. And we're hoping to correct those. I don't know if we're going to be able to or if we're going to have to start this process all over. But the arbitrator walked on this particular case. And it's not because it wasn't structured right. It's because the execution was not flawless, ladies and gentlemen. There were some parts that this man, and we'll call him David Clarence, which I'm just using that as a name for privacy issues, did not execute properly, okay? And please don't misconstrue me using David Clarence. It just popped in my head because I've been reading his stuff lately. The man's got phenomenal knowledge and great intel, so I probably should have used a different name. Anyway, not only expressly affirm the truth and validity of said facts set, established, and agreed upon between the parties to this conditional acceptance for value counteroffer claim for proof of claim, but respondents having agreed and consented to respondents having a duty and obligation to provide a requested and necessary proof of claim raised herein above, will create and establish for respondents an estoppel in this matter, and all matters relating hereto and arising necessarily therefrom. And 36. We're almost done here, ladies and gentlemen. Thanks for sticking with me. In accordance with and pursuant to this agreement, a contractual, consensual, binding agreement between the parties to the conditional acceptance for the value of the counteroffer claim and for the proof of claim to include the corporate government agencies, department constructions, constructs, who respondents represent serves, as well as all officers, agents, employees, assignees, and the like in the service, and the respondents will not argue, convert, oppose, or otherwise protest any of the facts already agreed upon by the parties set and established herein. And of the consequences arising therefrom, and any future remedial proceedings, actions, including binding arbitration and confirmation of the award in the District Court of the United States at the competent court under original jurisdiction, which reminds you, ladies and gentlemen, the federal courts have the original jurisdiction. It's so important. I can't remember. You find that under Title 31. I'll have to look it up. I don't want to mislead anybody. We're trying to stick to facts as best we can. But anyway, the federal courts have original jurisdiction. Will not argue, convert, necessary consequence, any future proceedings. The United States competent under the original jurisdiction in accordance with the Federal Arbitration Act, wherein this conditional acceptance for the value agreement contract number, and it's the contract number that was created, constitutes an agreement of all interested parties in the event of a default acceptance through silence, failure to respond when a request for summary deposition of any claims or particular issue may be requested and decided by the arbitrator. Whereas a designated arbitrator shall be chosen at random, who is licensed and duly authorized, and in the event of a non-acceptance of appointment as arbitrator and or any physical or mental incapacity to act as arbitrator, the undersigned shall have the authority to select any neutral, non-biased arbitrators that qualify pursuant to the state and federal laws, and any controversy or claim arising out of or relating in any way to this agreement or in regards to its formation, interpretation, or breach, and any issue of substantive or procedural arbitrability shall be settled by arbitration, and the arbitrator may hear and decide the controversy upon evidence produced, although a party who was duly notified of arbitration proceeding did not appear. The undersigned deems necessary to enforce the good faith of all parties hereto without respect to venue, jurisdiction, law, and forum the undersigned deems appropriate. Further, number 37, the respondent agrees to the undersigned can secure damages via tort claim and or financial lien on assets, properties held by them or on their behalf for all injuries sustained or inflicted upon the undersigned for moral wrongs committed against the undersigned as established. Now, ladies and gentlemen, the significance of moral wrongs, okay, that's spiritual. That's biblical. That takes us back to King James 16:11. Anytime you bring morality into something, comprehend, understand, know this to be true, that you're bringing the good Lord into the equation, okay? Because what should be done shall be done. We have dominion over the birds in the air, the fowl in the air, the fish in the sea, the waters. I mean, when we're talking about the NRD, they don't own anything. The state doesn't own the resources. They're vested in we, the people, by the heavenly creator who gave us all dominion over it. We're caretakers of this place because we don't get to take it with us, ladies and gentlemen. We're here to take care of it for the next generation, to hopefully provide a better, sustainable life for them. Okay? It's not about greed. It's not about gluttony. It's not about pride, the 7 deadly sins. It's about taking care of the next guy, not saying, screw the next guy, here's to me. It's about taking care of the next guy, the next generation. And you learn that in construction. You know, when you make a mess on the floor, you don't say, oh, the floor guy will get it. You clean your mess up and say, what about the next guy? Not screw the next guy, okay? Further, respondents agree to the undersigned can secure damages via tort or financial liens on assets, properties held by them on their behalf for all injuries sustained and inflicted upon the undersigned for a moral wrongs committed against the undersigned as established, agreed, and consented to herein by the parties hereto, to include but not limited to constitutional and impermissible misapplication of statutes, laws, provisions, and codes. In the above referenced alleged commercial civil cause, fraud, conspiracy, two or more involved, trespass of title, property, and the like, and all other known and unknown trespass and moral wrongs committed through ultra various acts, okay, of all involved herein, whether by commission or omission, ladies and gentlemen. Final amount of damages to be calculated prior to the submission of the tort claim and or the filing of a lien and the perfection of a security interest via the Uniform Commercial Code Financing 1 statement, established in the excess of $10 million USD or other lawful money or currency generally accepted within or by the financial market in America. And notice to respondents by invoice per respondent, failure and or refusal to provide the requested and necessary proof of claims, and thereby and therein consenting and agreeing to all the facts set, established, and agreed upon between the parties hereto. This conditional acceptance for the value of the counteroffer claim for the proof of claim becomes the security agreement under commercial law. See Uniform Commercial Code, Article 3, 8, and 9. Okay, ladies and gentlemen, they're important. We're just doing business here, baby, and we need to learn the business. But with that, I have to stop reading this. We are at number 38. I will do a second video because the intel that's within this is amazing. But I have a prior obligation for a lovely homeowner that has entered into a private agreement with me to build their dream in their basement right now. So I must be going. I really appreciate you guys' time. Keep studying, keep working hard, guys. We will prevail. We will get through this. But I wanted to share this knowledge. I'm actively going to take this on and try and correct the procedural errors that weren't executed properly. We went through a flood about the time that this gentleman was going through this process. He lost cattle, he lost yaks, llamas, all that stuff. And due to that, he dropped the ball and didn't serve his protest properly. And I believe after evaluating it, that's why the arbitrator walked. I believe that the process wasn't perfected, and because it wasn't perfected with a precision scalpel, the arbitrator had no choice but to walk away. I do think that it can be remedied. I do think it can be corrected. I'll work my little tail off to make it happen, or at least give it my best valiant effort. With that, I wish you guys a great morning, a good day, a wonderful weekend, and we'll talk to you soon.